Hi everyone, my name is Chandan and I welcome you all to this platform of Utilitarian IAS Indian Polity की 2000 MCQ की सीरीज में मैं आपका स्वागत करता हूँ. This is going to be test number 63 where we are taking another 20 questions of UPSC level. This is your self evaluation slide from where you can evaluate how many correct answer you answered and how many wrong. Based on that you can evaluate where do you stand in terms of knowledge in your polity. Now without wasting time, we are starting today's question with the 1240 question we already have completed. Consider the following statement, and today's most of the question is going to center around fundamental rights. So be thorough about your fundamental rights, and only when you are thorough about fundamental right, go ahead and attempt it. Consider the following statement about fundamental rights given in the constitution. They are not sacrosanct into the nature. That's correct, right? Fundamental rights can be amended and hence they are not sacrosanct in nature. We have to tell the correct statement. The directive word is correct, and make sure this habit, as soon you see the question, first of all mark on directive word, right? There would always be 5 to 9 question, 5 to 10 question that will be like mark the incorrect question, and our mind is accustomed in such a way that most of the time we just tend to make it correct statement, right? So make sure कि directive words पे आप लोग देखें. एक दो question जो हैं most of people make mistake, they do not read this directive word properly, and 1 or 2 question on an average every student is making this mistake. So make sure you guys at least don't make. They promote socio-economic democracy, so this is incorrect. They do not fundamental rights, actually this is a definition of DPSP. Fundamental right actually promote what you call political democracy. It is the DPSP which promotes socio-economic democracy. Now if I try to use the elimination technique, if 2 can't be part of answer, so this can't be answer, this can't be answer, this can't. Now again, without reading the 2 statement, just by using elimination technique, and one caution that I always have, one directive that I always have given to all of you students in most of our video whenever I am using elimination technique, that whenever you are taking any decision, especially in case of elimination technique, whenever you are taking any decision on basis of one statement, so here on the basis of second statement I did this elimination. So make sure that about this particular statement through which you are able to reach to your answer, right? About that particular answer you are 110% sure. Only then use the elimination technique, right? So I am marking this statement as correct because they are available only against this third statement is going to be wrong, not only against the state but also there are certain fundamental rights that are available against the private individual as well, like Article 17. If anybody even if I am practicing untouchability, if I am abusing any of the person belonging to a lower caste, right, that is violation of their fundamental right, and he or she can drag me into the court, right? So the point is that fundamental rights are not protected only against arbitrary action of the state but also against what you call private individuals as well. Right provided by 20 and 21 cannot be suspended during, so that's correct. So 1 and 4 is going to be correct, and hence B is going to be the right answer. Which of the following are unitary features of Indian Constitution? So federal feature had been asked into the previous I guess 61st question set that you had. In the federal feature we had asked written constitution, is it a unitary feature? No, this is actually a federal feature of our flexibility of the constitution. Yes, this is a unitary feature. Now most of you students who have not read salient feature of Indian Constitution properly might not understand that why flexibility of constitution is being described as a unitary feature of Indian Constitution. So and this I have explained in a few videos as well, and on salient feature we already have done a separate video, so you can search for salient feature of Indian Constitution and utilitarian IAS and watch that video where I have explained each and everything, the logic that why a particular feature is being described as unitary and why a particular feature is being described as a federal feature. So yes, this is a single citizenship. Yes, this is also unitary feature. All India services. Yes, this is also unitary feature. So 2, 3, 4 is going to be the answer, and hence C is going to be the right answer. The right to privacy was seen in news frequently. It is a fundamental right, not a constitutional, not a statutory, not a cultural, but the fundamental right. India adopted parliamentary form of government. Now from the parliamentary form, why it was chosen over this presidential form, why we did not go with the American system, why did we adopt this parliamentary? There was intense debate into the Constituent Assembly, right? K. Munshi, B.R. Ambedkar, Jawahar There were intense debate that why we should not be getting into. There were people proponents of presidential system as well. There are proponent of parliamentary system. Finally, we decided to go with the majority into the Constituent Assembly. Decided to go with or chose parliamentary system. Now we have to understand that why did we chose. So this is the purpose of this question. Correct statement we have to tell. It is the most stable form. No, parliamentary form in comparison to the presidential form is not a stable. It is unstable. You have the coalition governments when they draw the coalition element, when they withdraws the support from main party, right, the government becomes unstable. That is not the case in presidential system. It avoids the conflicts between legislative and executive. So that is a feature. Yes, legislative and executive, because in the parliamentary system, right, the executive comes within the legislature, from the legislature, and that's why the chances of conflict reduces. And that was one primary reason. It is more responsible. Yes, that is also correct. The parliamentary form is more responsible. Why it will be more responsible? First, that it comes within the legislature itself, and its continuance, right, the executive's continuance or the government's continuance is dependent on legislature's approval or legislative majority, and that is the reason why it is more responsible. But that is not the case in presidential system. Once president has been elected, right, except for the process of impeachment, he or she cannot be removed. So for these two reasons, second and third, that you will notice that we did go with the parliamentary system over the presidential system. So C is the right answer. Which of the following statement is or are correct about Indian socialism? Indian socialism is a form of state? No, it is a democratic socialism. We did not adopt the concept of state socialism as was being practiced by the then USSR. What we practice is democratic. Now again, if you do not understand what is this socialism, what was this state socialism, what is this democratic socialism, what was this Gandhian socialism, again all these things we have covered in our Indian polity video, and that's why our Indian polity videos has been so extensive, because elaborately we have covered these terminologies elaborately, and that's why I am not explaining it here. Indian socialism is form of states. No, that's it is influenced by Gandhian. Yes, that's correct. After the economic reforms of 1991, our socialist value got strengthened. No, after 1991, right, our capitalist value, right, was strengthened, and not the socialist value. So correct answer we have to figure out. Second only from my assessment is the second statement is only that is correct, and hence B is the right answer. Parliamentary system of India is inspired from British parliamentary system, but it is different from British parliament system as well. In what aspect, right? So India has republican system in place, while Britishers have a monarchical system. That's correct. Wahan constitutional monarchy hai, but we do have a republican system, despite having they are also practicing parliamentary system, and we are also practicing parliamentary system. Their head of state is inherited, right, while ours head of state, that is president, is elected. Indian system is not based on doctrine of sovereignty of parliament. That's correct. Okay? The kind of sovereignty that their parliament enjoy, we do not have any concept of doctrine of sovereignty of parliament. What we do have is game of checks and balances. Checks of balances between what? Legislature, executive, and judiciary. None of these three organs of the state is powerful enough, right? Everybody just keeps balancing each other. Legislature to the executive to some extent legislature, then judiciary to these both, right? So both the statement happens to be correct, and hence C is going to be right answer. One prerequisite before attempting these questions, one prerequisite, because I do not make you guys understand each and everything. I do not explain, because I do have expectation that this is not the right time for the explanation. We are into this July, right? In October you do have prelim, right? By now I expect that every one of you would have revised Indian polity at least 3 to 4 times. So there is no point. It is just you are testing yourself, and you are just trying to give how we should be attempting. That is the mindset that I am trying to make into these kind of questions, how you should approach the question. That is what I want you to look into these videos. ठीक है. Now we are moving to the question, which of the following statement is are incorrect about right to education? Incorrect it is asking. Okay, it is the only provision into the constitution for the free and compulsory education for the children. That's incorrect. It has been amended by 86th added by the 86th constitution, so that's correct. The right is available to foreign national as well. That's correct. Article 21 is applicable or available to foreign citizens as well. So first statement is only that is going to be incorrect, and hence A is the right answer. Which of the following is are not directive principles of the state policy? Not right. Socialist on socialist principle, right? So DPSP has been divided not constitutionally but by a section of academician or constitutional expert into three major groups. You have this socialist, then you have liberal, okay, and then there is third group as well. So in three division DPSP has been divided. So equal pay for equal work, this is socialist principles, okay. Free legal aid, socialist principle. Participation of worker into the management, socialist principle, right? Protection and improvement of environment, 48A, right? That was added by 42nd constitutional amendment. So this is a liberal DPSP and not socialist. So it has asked which of the following are not. So this is not the socialist principles of the DPSP. So 4 only is going to be the right answer. Consider the following statement about preamble of the Indian Constitution. It was based on the objective resolution drafted by Dr. B. Most famous statement. Objective resolution was drafted and proposed by Dr. Jawaharlal Nehru and not the Dr. B.R. Ambedkar, right? So this statement cannot be like, nobody can mark, nobody can claim that this question I do not, this statement I do not know. So let us try to use elimination technique here as well in this question. If the one cannot be part of answer because correct has been asked, so this can't be answer, this can't be answer, this can't be answer. So this is the only possible answer. Without reading any of these three statements, I was able to reach out to your answer just on the basis of this statement. Okay? So B is going to be the right answer, but I'll instruct you to read these, pause the video and read these three statements as well. At least you will have some amount of learning, right? Next question, 1250. Consider the following statement related to Indian Constitution. The Indian Constitution was first to begin with a preamble. No, it was the US Constitution which was first to begin with preamble. The 42nd Constitutional Amendment added only socialist and secular into the preamble. That's incorrect again. There was this third word as well, that was integrity. Being a sovereign state, India can neither acquire a foreign territory nor, that's also incorrect. And then the liberty conceived by preamble or fundamental right is not absolute, that's correct. So incorrect we have to tell. So 1, 2, 3 is going to be incorrect, and hence C is going to be the right answer. Consider the following statement with respect to parliamentary form of government. One question regarding parliamentary form of government we already have attempted. So correct statement, Prime Minister is the head of the government in this system. That's correct. The minister are collectively responsible to Parliament in general for all their acts of omission and commission. That's correct. In general, right? Specifically to the Lok Sabha, but in general they are responsible to the Parliament. So that's correct. In the system, in this system a person ceases to be MP. It's not this ceases, but rather ceases to be MP if he is not elected to the house within 6 months. So that's correct. The executive enjoys the right to get legislature dissolved in the parliamentary system. So that's correct. The government at this moment, you have government led by Prime Minister Modi, so he does have power, because since he has majority, he can ask president at any given time that hey, Lok Sabha को आप लोग president को बोलेगा Lok Sabha आप dissolve कर लो, right, और कर सकते हो. So president will have to dissolve the Lok Sabha at that moment because they have majority. So all the 4 statement happens to be correct regarding the parliamentary system, and hence D is going to be the right answer. Which of the following doctrine are applicable in India? Doctrine of sovereignty of parliament. No, this doctrine is not applicable. This is applicable in Britain but not in what you call India. Doctrine of legal, that's correct. Doctrine of eclipse and doctrine of, so 2, 3, 4 is going to be the right answer and B is the right answer. In part 3, the Indian Constitution, fundamental rights are enumerated. The definition of state include which of the following authority? Article 12, right? Article 12 extensively we have covered. Parliament of India, yes, this is state. Legislatures, yes, this is state. LIC and ONGC, yes, this will be state. District board, yes, this will also be part of state. So 1, 2, 3, 4, that is C is going to be the right answer. Article 14, right to equality. Right to equality before law. Which of the following statement is are correct regarding right to equality or equality before law? Equal protection of law is positive obligation on the law to ensure equal protection of laws by bringing necessary social and economic changes. That's correct. Fundamental rights enshrined in Article 14 are applicable or available only for the citizen of India. No, that's incorrect. Article 14 is equally applicable or available to foreigners as well, right? So first only is going to be the correct answer and A is the rule of law is one of the basic structure of the constitution. Which of the following exceptions, means rule of law का जो है, right, वो article 14 का ही exception actually, right to equality का जो exception है वो किस किस को applicable है, that is what has been asked in this question actually. The president shall not be answerable to any court for the exercise and performance of power and duties. That's correct. No member of parliament shall be liable to any proceeding. That's correct. The United Nations organization and its agency enjoy the diplomatic immunity. That's correct. Ambassador, councillors, all these people enjoy immunity under this thing, right? And United Nations organization, UNO also, right? So that enjoys the majority. So all three statement happens to be are the exception of rule of law or right to equality, that is article 14. ठीक है. Next question, which of the following fundamental rights and their deviation from constitutional article is correctly matched? Right to timely medical treatment in the government hospital, yes, this is a part of article 21. Right to commercial advertisement, article 19 में right to profession का एक part है, और right to rather free speech and expression का भी ये part हो सकता है. Right to peaceful protest, article 416 में नहीं, article 19 में covered. Right to privacy, article 21 में, right? So what is the ask? Correctly matched, right? So 1, 2 and 4 is correctly matched and hence B is going to be the right answer. Considering the preamble of Indian Constitution, India is a secular state, which means the state is anti-religion and condemns all the religion. No. This is the specialization and this is where Indian conception of secularism is different from Western conception of secularism. Western conception of secularism is कि नहीं, हम anti religion, state will not adopt any kind of religion, ठीक है. But here we what with the concept of secularism that we do have is equidistance. We maintain equal distance from all the religion. If we have to provide support, we will be providing support to every religion. If we have to maintain the distance, we will maintain distance from every religion, every possible. So we are neither religious state, we are neither irreligious state, we are neither anti-religious state, ठीक है. So that's incorrect. The preamble secures all citizens of India liberty of belief, faith and worship. That's correct. The state is neutral in matters of religion and does not uphold any particular religion as a state religion. That's also correct. Correct पूछा है, so 2 and 3 is going to be correct. So C is the right answer. Which of the following statement is are correct related to the habeas corpus? Habeas corpus is issued to protect personal liberty of an individual against the arbitrary actions of the state only. Again this becomes incorrect because arbitrary अगर arrest हुआ है, arbitrary detention even if is being done by or attempted by a private person, court can issue that habeas corpus writ to a private person as well. So if this one can't be part of answer, so this can't be answer, this can't be answer, either this or this. Let us read it, right? Habeas corpus relief may be issued to obtain custody. That's correct. Legislature which enacts the law depriving a man of his personal liberty be empowered to make laws under article 246 of the constitution. So 2, this is also correct and hence 2 and 3 is going to be the right answer, that is B. With reference to the tribunals in India, which of the following statement are correct? The original constitution did not contain any provision with respect to article. Very correct, right? Original constitution, this concept of tribunals has been added into article 323A by constitutional amendment, ठीक है. It was not part of original constitution. 42nd constitutional amendment deals with tribunal, that's correct. CAT has original jurisdiction in relation to the recruitment of public servant, that's correct. So 1 2 3 is going to be, that is D is going to be the right answer. Consider the following statement related to RPA, Representation of People Act. Representation of People's Act provide for election of House of Parliament only, that's incorrect. House of Legislature के साथ भी RPA 1951 डील करता है. The provision as to disqualification on grounds of defection are mentioned into the grounds of defection are mentioned into the schedule 10 and not into the RPA. Incorrect पूछा हुआ है, right? So incorrect is going to be both 1 and 2 are going to be incorrect, and hence C is going to be the right answer. So with this we are wrapping up this session as well. We'll meet you into the next session. Till then, bye bye.